you, Senator Mitchell. Thank you, Madam Chair and members. Currently, there's no distinction in law between an adult who is selling sexual acts from the adult who is purchasing sexual acts, or from an adult who is purchasing sex from a minor. For the purposes of data collection, SB 420 divides Penal Code Section 647B into 3 separate sections in order to separate the buyers and sellers of human trafficking and prostitution. 1, adults offering to engage in commercial sex acts with a buyer. 2, solicitors of commercial sexual acts from adults. And 3, solicitors of commercial sexual acts from minors. Research proves that demand for sex acts drives the market for exploitation, especially among children. Under current law, any person who offers to engage in or engages in any act of prostitution is guilty of disorderly conduct. It's time we call purchasing of sex acts what it is and separate out the buyers from the sellers, who more often than not are victims of sex trafficking. SB 420 is a necessary first step in addressing the demand side of human trafficking. My staff and I have been working with the committee and the Alameda DA and Los Angeles DA on amendments that further define the elements of prostitution, as noted in the committee analysis, and these amendments I'll be taking today. By making a distinct separation of the penal code between the individuals involved in prostitution, the Attorney General will be able to collect data that shows how many children and adults are being purchased for sex. By U.S. State Department estimates, sex trafficking is a $32 billion industry in this country, and 50% of trafficking victims are minors. Yet, according to the 2007 final report of the California Alliance to Combat Trafficking and Slavery Task Force, California lacks comprehensive statistics on human trafficking. Easy access to the internet enables human beings to become ensnared and sold across state lines. The FBI has determined that 3 of the nation's 13 high-intensity child prostitution areas are located here in California. Data generated by SB 420 is essential for creating solutions to a disturbing public safety enemy in our communities, especially among at-risk youth. I have here today Casey Bates, Deputy District Attorney in charge of human trafficking for the Alameda DA. Mr. Bates is very knowledgeable on the subject of human trafficking and the need for SB 420, as well as other expert witnesses.
Good morning. Thank you for giving me the opportunity to be heard today. It's a pleasure to be here again. Senators, the reason that this is an important bill is that human trafficking is composed of 3 component parts. You have those that exploit, those that are victims, and those that buy. Right now, we have a situation where we're capable of knowing the number of individuals that are charged with the exploitation of children and adults that are involved in the sex trafficking industry. But the other 2 component parts we're incapable of breaking out to describe what the lay of the land is in terms of how these individuals exist within the criminal justice system. This bill, SB 420, simply divides those that buy from those that sell. It adds no additional penalties, and it is a good data bill. And for that reason, we've asked that this bill be brought, and Senator Huff has very eloquently stated the reasons why it's needed. So I will yield back any time that I have. Thank you.
Madam Chairman, members, Dan Filizato on behalf of the Los Angeles County District Attorney's Office. For the reasons stated, we're in strong support.
Thank you. Madam Chair, members, Marty Veronica on behalf of the California District Attorneys Association. We're also in support of this measure. Thank you.
Thank you. Others in support of the bill? Deputy District Attorney Laura Tanny on behalf of Bonnie DeManna, San Diego County District Attorney, in support. Thank you. Speakers in opposition to the bill? Seeing and hearing none, are there questions or comments from members of the committee?
Madam Chair, I'm ready to
Anderson.
move the bill when you're ready.
Okay, Senator Leno.
Thank you, Madam Chair. Senator Huff, I understand what you're trying to do with the bill. It seems to make sense. You mentioned that this will allow the Department of Justice to collect data. Can they not do so now?
Right now, I can yield to one of these guys that actually has to deal with it, but it's just one section, so it doesn't differentiate the difference between somebody that's purchasing sex or versus the prostitute who is soliciting. And so we want to do that as well as if they're a minor. So we'd have 3 data points instead of just 1 right now.
And any reason why the bill wouldn't direct the DOJ to do this?
Want to answer that question?
No. So to your first question, there's no way to extract that data. It has to be a different charging section in order for us to do that.
And that's the part I get.
Yeah, thereafter DOJ can collect it.
Okay. And any reason why the bill wouldn't direct the DOJ so we make sure that this would happen?
I don't believe that's an issue.
I was going to say, Senator Leno, for example, in our office, the district attorneys, with the new charging sections, we will have all of that information, because if we're going to be charging a John, we would have the 647B2. So all the collection on any charges filed would already be compiled either by the district attorney or the city attorney.
So it'll happen at the local level?
Yes.
Okay.
And it will be sent to DOJ from the local level? So we assume there will be no choice but to report it in this disaggregated way?
When a case is adjudicated, that information is reported to DOJ. It's my understanding that we're going to work with Department of Justice to see if they will compile it with the new adjudication, or how they're going to compile it, and we'll address that.
Okay, I have to say, in the past, we've had difficulty getting information sometimes broken out in certain ways. Senator Leno might have a very good point in that, but it seems to me that maybe if it's going to all get reported in this disaggregated three-tier way, that DOJ would have to work harder to get it aggregated again?
It would be my assumption that if it's going to be reported that way, that's how DOJ would compile it.
And I think they can.
Okay, so my understanding is that they will do it. Yeah, and that will be a good thing. So with that, Senator Huff, would you like to close?
Yes, with the amendments that we're taking, all opposition has been removed. I don't have a formal letter on that yet, but it has come in a couple of emails.
You're taking
that
the
will be
amendments on
clarified.
page 10?
Yes. And the bill is also supported by the California Police Chiefs Association, PORAC, and California District Attorneys Association. I ask for your aye vote.
Thank you. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Leno.
Aye.
Leno, aye. Lou. McGuire. Monning.
Aye.
Monning, aye. Stone. Stone, aye.
Thank you very much. That bill is out. And, we're going to hold the roll open for the absent members that has enough votes to pass. We'll hold it open. Senator Mitchell.
Good morning, Madam Chair.
Good morning, Senator Mitchell. This is item number 2, SB 277.
227.
Thank you. Yes. That's-
277 is another bill. I don't want to present on that one. 227, yes. Not 277, we know that one. Yes. Thank you very much, Madam Chair and members. I appreciate the opportunity to present to you Senate Bill 227, which prohibits the use of a criminal grand jury when evidence indicates a peace officer's use of excessive force or a firearm contributed to the death of a person being detained or arrested by the peace officer. Let me start by accepting the committee's recommended amendment on page 6 and thank the committee staff for working with us and trying to clarify current law into that area. And it states that we're clarifying that nothing in this bill impacts the grand jury's ability to investigate under Penal Code 918. The grand jury system has recently come under fire nationally for a variety of reasons. Specifically in this case, there's several incidents of officer-involved deaths. To the general public, the outcome of the criminal grand jury proceedings can seem secretive, unfair, or inexplicable. The criminal grand jury system lacks transparency and is not adversarial in nature. No judges or defense attorneys participate. The rules of evidence do not apply. There are no cross-examination of witnesses, and there are no objections. In looking into this issue, we've been struck by the lack of available information on how criminal grand juries are used in our state. There appears to be no data on the number of cases that are heard, the kinds of cases that are heard, or the outcomes of those proceedings. Some counties, specifically my own home county, LA, and Santa Clara counties, have adopted policies that preclude the criminal grand jury being used in cases where an officer's actions may be the cause of the death of a suspect. However, these policies have been instituted at the will of the county's district attorney and are subject to change at any time. There are a number of articles and scholarly articles and attitudes with regard to the criminal grand jury system and whether or not it continues to be perceived as a necessary or valuable tool. My argument is that the public has a right to know that the allegation is taken seriously and is investigated thoroughly in the event of an officer-involved shooting or excessive force that leads to death. The use of the criminal grand jury has fostered an atmosphere of suspicion that threatens to compromise the very nature of our justice system, and as such is not serving its intended purpose as a tool of the community. To clarify, this bill does not create a different path for these cases. It would merely require that peace officer cases in these specific incidents be sent through the preliminary hearing process as it would for any other private citizen. I have some witnesses here, members of the bar, who would like to express their support for the bill, and I respectfully ask for your aye vote.
Thank you. Witnesses and support.
Good morning.
Hit your mic on, hit the red button. There you go.
Oh,
There you go.
good morning. I am Tom Meyer. I'm a retired lawyer, and I'm aware that I think maybe the only opposition to this bill is a letter that the statewide district attorneys sent in opposition to it, because a tiny little bit part of their turf would be affected by this. And I have written a 2-page rebuttal to their letter for members of the committee to consider. And I would ask leave of the chair and the committee to submit that. I've given copies to the Sergeant at Arms.
Who's given us copies?
And instead of going into a long speech, I rely on what I've said there. I guess for what it's worth, the only statement I would make is I think the vast majority, the overwhelming majority of California lawyers, civil and criminal, would support this bill. Thank you.
Thank you.
Madam Chair and Senators, my name is Frank Leibman. I'm the immediate past president of the Criminal Trial Lawyers Association of Northern California, and I believe, too, that a letter that I wrote was distributed by the Sergeant of Arms. Our association has approximately plus or minus 500 members, and if I may immodestly say so, some of the best criminal defense lawyers in the country. We stand in support of this measure. Frankly, I believe that it is a modest measure because of its scope. It refers to a detainee's or arrestee's death, but not great bodily injury. That is an appropriate scope of the statute, which we would even suggest ought to be expanded, because we do have a system that works. We have a preliminary hearing system, and that system is one in which a charge is filed, and in an atmosphere of total transparency, a judge, with the assistance of a prosecutor and a defense attorney, each with the ability to use court process to bring witnesses to court, can examine the evidence, and ultimately there is a determination. If this bill passes, what it accomplishes is modest. What it says is if an event occurs and it is not charged, there is one and only one person responsible, and that is the district attorney of that county. And there is no ducking that responsibility. We submit that it is appropriate on election day for the public to know those charging decisions or not. And it is inappropriate for there to be some sort of cover, if you will, where the grand jury could be pointed at, as unfortunately, as we all know, happens in places from Missouri to New York recently in officer-involved shooting or excessive force cases. I would also recommend to you the unpersuasiveness of the California District Attorney Association letter in pointing out a number of penal code provisions that provide allegedly safeguards to the system. They don't when a case is not charged. Those are in place, and this legislature has done well to put them in place in a situation where there is a case charged, but they simply don't apply when a case is not charged.
Others in support, me too's, please.
Jim Lindberg on behalf of the Friends Committee on Legislation in California, in strong support.
Madam Chairwoman and members, Francisco Baca on behalf of the ACLU, we urge you to move the bill forward. Thank you.
Ignacio Hernandez on behalf of CACJ in support of the bill.
Thank you. Others in support?
Bobby Walker with Public Advocacy on behalf of California Public Defenders Association in support.
Thank you. Others in support? Seeing and hearing none. Those in opposition to the bill?
Madam Chair, members, Marty Veronica on behalf of the California District Attorney's Office. I regret to inform you that we are opposed to Senator Mitchell's bill, which would prohibit the use of grand jury in those cases involving fatal use of force by police officers. While the use of the grand jury is relatively rare in California in cases of officer-involved shootings, we disagree with the principle of taking away a valuable prosecutorial tool that in certain situations is both useful and necessary. I cite just one example. Witnesses who would be reluctant to testify publicly for fear of retaliation or being labeled as snitches. While there may be fundamental deficiencies in the grand jury systems of other states, we do not believe that those deficiencies exist in California to justify modifying the current grand jury procedure here in California. To further talk about grand jury practice in California, I've brought along San Francisco Assistant District Attorney Jerry Coleman, a recognized grand jury expert, to discuss the process further.
Thank you. For 1 minute, please.
Madam Chair and Committee, I retired from San Francisco DA's office after 35 years as a prosecutor and grand jury expert. I still consult for them on police misconduct and grand jury matters, and I'm currently the San Francisco Indictment Grand Jury's legal advisor. I've held that position for 23 years. I have also sent a corrupt police officer to prison. I've supervised grand juries that have indicted officers. I've taken police excessive force death cases to the grand jury. So I know what goes on in the grand jury. I've handled more grand jury matters than most prosecutors in the state of California. Unlike federal grand juries, California grand juries do require application of the rules of evidence. Only admissible evidence at a trial can come in at a grand jury, or we lose the case. So I'm here to tell you that this bill is the wrong solution to a problem that doesn't routinely exist in California. It's a reaction to matters out of state, and it might have the unforeseen consequence of less prosecutions in police force cases. And let me explain that. If a police excess force case, or any case, is strong, a prosecutor can easily seek an arrest warrant and go to a public preliminary hearing. 95% of our cases go that way. But if a case is weak or uncertain, and police force cases often are, they have equivocal evidence, they don't all have videos, there's forensic evidence, we can't simply charge an iffy case and let a preliminary hearing judge decide it. Our ethical duty to charge a case is based on the ability that we can win the case beyond a reasonable doubt at trial. So without a grand jury to investigate the case, to subpoena witnesses to testify, to get them to testify under oath, the majority of cases like this, we would have to decline to prosecute. It's not ethically appropriate to just let a preliminary hearing judge hear a case, because that requires an arrest warrant and then someone in custody for 2 weeks, and then finally the public preliminary hearing. But there is an easier solution. If you want fair and transparent grand jury proceedings accountable to the public, and the author says that is exactly what she wants, one, we can do it now under California. 939.1 of the Penal Code allows for actually public grand juries in cases of official dereliction of duty. And in Santa Clara County, 2 such cases were brought on police excessive force deaths in the last 12 years. One got an indictment, one didn't. So that's already the law if chosen by the DA, the grand jury foreperson, and the judge. But there's another statute that I think would work equally well. 938.1 of the Penal Code says you only get a transcript in a grand jury if there's an indictment. That could easily be amended, and I've actually drafted language to do that, given it to Senator Mitchell's office, that would allow transcripts, even without indictment, in police excess force cases on court approval. Now, if a prosecutor had a near certainty of a transcript, whatever the result, it would require the prosecutor to put on the case as fairly and as fully as they can. It would be a motivation to call all necessary witnesses and explore evidence without favor to anyone except the truth. That's the legal solution to this possible problem. With that amendment, our state's prosecutors would support it. As currently drafted, we have to oppose it because it forces us into an unethical position.
Are there questions? Are there others in opposition? Seeing and hearing none, are there questions or comments from members of the committee? Senator Leno and Senator Stone.
Thank you, Madam Chair. I do have a question for Mr. Varenikar.
Yes, sir.
You had pointed out that there was one very important reason for the use of the criminal grand jury, and that was the concern that a witness, potentially a snitch, would be fearful to step forward. Given the very narrow slice that this bill addresses, police-involved shooting or excessive use of force by an officer that leads to death, that's very specific.
Yes.
Are you suggesting that why would we have concern that a snitch wouldn't come forward? Is it out of fear of the police? I mean, why? No, I don't understand how that would work.
I'm not talking about the use of the word snitch as in some sort of police informant. I'm talking about an individual in the neighborhood who saw something and who, fearful of being labeled a snitch, would testify publicly as to what they saw. That was
in a police-involved shooting.
Yes, yes, and that was some concerns that were raised during the grand jury proceedings in Missouri, as an instance, and it was also there have been individuals who have most recently in a public prelim the other day involving Suge Knight, who's being prosecuted for running over an individual in Los Angeles, where the individual who was run over by the pickup basically on the stand denied that he had been run over by Mr. Knight, and on the stand indicated that he did not want to be a snitch, did not want to be considered a snitch. And I think that's one of the concerns. If we are going to get truly to the bottom of what occurred, we've got to be able to provide a forum for those witnesses who are reluctant to testify about what they saw in a controlled environment. Thank you.
And with regard to revealed transcripts?
That's after the fact. And that may be after the situation has cooled sufficiently that an individual would be comfortable with that information being out there.
Thank you.
Senator Stone.
Thank you, Madam Chair. First, let me qualify my questions by saying that any officer that abuses their power in any way, including the loss of an innocent civilian, deserves to be fully prosecuted. And I certainly understand the author and our altruism in trying to bring this forward in the light of events that we've witnessed throughout the country. But I'll say, as a pharmacist legislator and quickly learning laws, the criminal grand jury system, as I understand it, there's 19 members, is that correct? And it requires like 12 members to move forward with a indictment, is that correct?
It varies from county to county, Senator, but most counties have 19 grand jurors. Los Angeles has 23, and counties with less than 25,000 in population have 14.
Okay, I think in Riverside County, I think we have 19, and I believe it takes 12
to get an indictment.
To force an indictment. And so, and I'm aware of the scrutiny that goes on, at least in our county, in carefully selecting members of the criminal grand jury that is kept, somewhat confidential. If a grand jury comes out with an indictment, then in a way we're kind of expediting justice, in my view, because we're eliminating a preliminary trial. Within 60 days, you go to trial, which I think, in these more heinous cases, I think the author and many others, including myself, would be very happy to see that justice is coming faster rather than later. If a criminal grand jury decides not to file charges, it's my understanding that the district attorney still has the final say.
That's correct, Senator.
So we basically have transparency in two different situations. Transparency with a criminal grand jury, and you said in 939.1, was it, that the public grand jury transcripts can be made public, is that correct?
939.1 is an actual public grand jury hearing of these cases.
Okay, so there is some transparency there when we see the deliberations that will allow a grand jury to ultimately come up with an indictment or not an indictment. And I'll give the other side that I would say that in most counties, the elected sheriff and the elected district attorney, in many cases, have a very cozy relationship. They have to work together. And in many cases, the district attorney may need many of their sheriff deputies to testify on behalf of many other cases. And so here you have one individual that's going to make the difference between somebody being indicted and not indicted. You could, when a district attorney says he's not filing charges, to my understanding, he doesn't really have to give all of his records up to articulate why he came to that conclusion. Is that correct?
It is correct, although there may be some access to those records for public
Right.
outcry
And
or
then
Freedom of
certainly-
Information Act request.
And then certainly the district attorney, if he doesn't file charges in an appropriate case, he's going to come under scrutiny like you had articulated before the voters. And if we have somebody that unethically doesn't file charges that should file charges, then hopefully they're going to get voted out of office. So to me, it seems like you're going down dual paths here. It's somewhat of a checks and balances where you have two opportunities, two bites at the apple to prosecute an officer that is allegedly killed somebody inappropriately. One, the grand jury, where you've got to have 12 out of 19, at least in our county, that are moving forward with an indictment that will expedite the hearing process, getting it to hearing within 60 days without a preliminary trial, or even if the grand jury says, no, we're not going to indict, the district attorney then has the ability to use all of their evidence going down a parallel path, can file charges. There is a preliminary trial, and then it goes to, it gets adjudicated. So it seems to me the transparency was a large issue here, that grand juries were maybe being biased and not wanting to prosecute one that there was ample evidence that that officer was involved in the killing of an innocent person unnecessarily. So I'm not sure what I'm missing. There's transparency in the public grand jury that you articulated. There's a little bit less transparency with the district attorney when they file charges and don't file charges. You get an expedited hearing when you go through the grand jury process, and if the grand jury doesn't act, the district attorney can. So I'm not sure what I'm missing here.
Well, one thing I need to comment about, your remark about dual paths.
Okay, and I'd like everybody to be as succinct and get to the point as possible, or we are not going to be able to hear the bills today, so.
My final remarks on dual paths, Senator. There are two ways to get to trial in California, grand jury and preliminary hearing, and both have the same standard of law. But there's a crucial difference between them that this bill doesn't quite understand. A preliminary hearing is a post-charging proceeding. DA has already filed charges under an ethical standard. Grand jury is an investigative proceeding pre-charging. If you're not sure where to go, you call witnesses, you develop evidence, and then you can get an indictment. So that's the difference between them. If you take away the grand jury as that investigative tool that could seek an indictment in a police shooting case, then you leave only the public preliminary hearing, which with an iffy case makes it awkward and may actually result in less prosecution.
Thank you for the clarification. Thank you, Madam Chair.
Thank you, Senator Stone. Senator Mitchell, you've heard the arguments. I hope you'll address them in your close.
I will attempt to. I think today's discussion reflects the broader movement afoot that calls into question the value of the grand jury process across the board. And there are numerous articles that have been published by members of both the bench and bar, those who are well-versed and are very familiar with the grand jury process, who argue on both sides of the coin on this issue. There have been books that have been written by members of grand juries, most recently a reporter from New York that talked about the inherent bias he witnessed as a grand juror. I would say that there are people like the retired judge here today. There are far and few between who consider themselves well-versed and experienced in the grand jury process. The general public is not. It is a closed process that many believe has no place in the gathering of data and information with regard to, again, the very narrow scope of this bill, that's incidents where there are police involved, shootings or excessive force that result in death. With regard to the Suge Knight example that was given with regard to his preliminary hearing, let me very simply say that it is not germane at all to the narrow scope of this bill. To my knowledge, Suge Knight is a rapper, not a peace officer. Suge Knight is the indeed accused killer in this case. And so how the notion of people being concerned about coming forward in that case relates to the scope of this bill, I am certain, Madam Chair, I do not know. Thirdly, I would say the reference to grand jury processes and systems in other states is interesting. However, I also don't think it's relevant to the aspects of this bill or our experience in California, because in the California system, there are still a number of issues that take place outside of the typical jury system that lead to, again, a lack of transparency and potential bias through that process. Again, this bill was intentionally very narrow in scope in an effort to do statewide what in effect is practiced in 2 counties in LA, in California, Los Angeles and Santa Clara, which is to take it out of the hands of a grand jury and make sure that the preliminary hearing process, which applies to every other resident of this state, applies to peace officers as outlined in the bill as well. And with that, we ask for your aye vote.
Thank you very
I move
much.
the bill.
The bill has been moved as amended. I think the bill, having sat through a number of community meetings in my district, and the large hearing that we had with the joint public safety committees of both houses, I think this bill is an important one to pass at this time. So I'll be voting aye. Please read the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Anderson, no. Leno. Aye. Leno, aye. Lou. McGuire. Monning. Stone.
No.
Stone, no.
That bill is on call. And Senator Mitchell, you have another bill as well.